With regard to the dissolution of marriage, the marriage can be dissolved either by extrajudicial divorce or by the judicial divorce. So in our previous video, we have covered the extrajudicial divorce. Today, we are going to look into the judicial divorce. So here, under the judicial divorce, there are two aspects has to be covered, that is Lian and Faskh. So in addition to this Lian and Faskh, a Muslim woman, she will accrue the rights under the Dissolution of Marriage Act of 1939. So a Muslim woman, she gets the rights under the Dissolution of Marriage Act of 1939 besides this Lian and Faskh. So today, let us see what are all the rights a Muslim woman she can get under the Dissolution of Marriage Act of 1939. So before coming into this act, this Lian and Faskh, which were prevalent among the Muslim society. So what is Lian, what is Faskh, we can see in this video, and we can discuss the rights of women under the Dissolution of Marriage Act of 1939. Here, the Muslim law givers also provided for dissolution of marriage by a decree of the court. It's called turf, or literally separation. So here it has been provided even before the implementation of this act. The Muslim law givers has provided a divorce which was in the form of the decree of the court. Here there was also the Muslim wife. She has got the right of preferring a complaint before the Qazi or judge demanding a divorce from the court. That means a Muslim woman, she gets the rights. She gets the right on happening of the certain event. So at that time, she can prefer a complaint before the Qazi or a judge demanding a divorce. So this can be called as a judicial divorce. So whatever are the Quranic injunction and the traditions, what has happened in India may be summed up in the words of Krishna here, judge. So here justice, that is Muslim law as applied in India, has taken a course contrary to the spirit of what the prophet of the Holy Quran has laid down, and same misconception vitiates the law dealing with the wife of right to divorce. So this we can see, that means what are the developments has taken place by implementation of the Dissolution of Muslim Marriage Act of 1939. So before going to the Dissolution of Muslim Marriage Act of 1939, let us see what is Lian and what is Faskh. So here, if a Muslim husband falsely charges his wife for adultery or denies the paternity of his child, and charge is proved as false, the wife is entitled to sue for divorce. So this is called as Lian. That means, in brief, we can say that what is meant by Lian is a Muslim wife, she accrues the right to get separated from her husband because of the false charge on her with regard to the commission of the adultery. If the Muslim husband falsely accuses his wife for the charge of adultery or denies the paternity of child, then a Muslim woman, she accrues the right to file the petition before the Qazi or the court. So this can be called as Lian. And here, what is meant by Faskh? So before going to Faskh, let us see the other process of the Lian. So it may be concluded to Lian, which may leads to Faskh and ultimately turn into annulment of marriage. That means Lian means it is a right a Muslim wife gets when she falsely accused by her husband for the commission of the adultery. So here by Lian, a Muslim wife, she gets the right. So she can ask for the annulment of marriage by way of the Faskh. That means Faskh means she is entitled to get the annulment of marriage or abrogation. So under Faskh, a wife under Faskh can give an application to Qazi or court for annulment of her marriage. So if the Qazi or court is satisfied, then annulment of the marriage will be possible. So here with regard to this aspect, Prophet has said that if a woman is prejudiced by a marriage, let it be broken off. That means it has been accepted by the Prophet Muhammad. That means if she has been prejudiced, that means she has not been given justice, she has been falsely accused of, then it is better to get rid of such marital tie. So here, even before the commencement of this dissolution of Muslim Marriage Act of 1939, there the practices of this Lian and Faskh was already present in the Muslim society. So here, what is the specialty, what is the relation of this Lian and Faskh with regard to the dissolution of Muslim Marriage Act of 1939 means it also gets the place under the dissolution of Muslim Marriage Act of 1939 under section clause 9 of the Act. So let us see what are all the specialties, what are all the salient features of the dissolution of Muslim Marriage Act of 1939, where a Muslim wife, she gets the rights to get her marriage dissolved. So let us go to the dissolution of Muslim Marriage Act of 1939. Here, before the dissolution of Muslim Marriage Act of 1939, Indian courts granted a decree of divorce to the wife only on two grounds, that is lian and apostasy. So apostasy means the conversion. So conversion to other religion. That means here on these two grounds, the divorce has been given to the Muslim woman, that is lian and apostasy. Here, with regard to the Muslim Marriage Act of 1939, Section 9 proves to be very much important for the Muslim wife, where she can get the rights on the 9 grounds which has been given under the Section 2 of the Muslim Marriage Act of 1939. So, among these 9 grounds, 7 grounds are concerning with regard to the matrimonial guilts committed by her husband. So, here she will get the right under the 9 grounds under the Muslim Marriage Act of 1939, whereby she can ask for the annulment of marriage or dissolution of marriage. Earlier, only the Muslim husband has got the absolute right with regard to the divorcing his wife. But the woman also has got the right, but that is very much limited. That is, one is lian, another is apostasy. So, here, after the dissolution of Muslim Marriage Act of 1939 came into being, the divorces, that is the annulment of marriage was used to be taken place on the only 2 grounds, that is fault grounds of the divorce and breakdown of marriage as a ground of divorce. So with regard to the fault ground of divorce, we can refer this aspect under the dissolution of Muslim Marriage Act of 1939, where a court can grant a decree of divorce on these grounds. Here, with regard to the granting the divorce to the Muslim woman under the section 2 of the Muslim Marriage Act of 1939, these points has to be considered. Under these points, a Muslim wife, she gets the right to file the petition for the annulment of her marriage or cancellation of her marriage. So here, well, let us see all these grounds one by one. The first one is the whereabouts of the husband are not known for a period of 4 years. So if the whereabouts of the husband are not known to the wife for a period of 4 years or more, the wife is entitled to a decree of divorce. But such a decree will not take into effect for a period of 6 months from the date of such decree. That means here under section 2, a Muslim woman, she gets the right when her husband whereabouts are not known, and the court can grant a decree of divorce, but such decree will not come into existence all of a sudden. So the Muslim wife has to wait for another 6 months after passing of the decree. So if the husband appears in this period, he can ask for the restitution of conjugal rights. So then the court may set aside the decree. So this aspect has been discussed under the section 2. Subclause 1 of the dissolution of Marriage Act of 1939. So here the second ground is the failure of the husband to provide maintenance to the wife for a period of 2 years or more. The second ground is that if the Muslim husband has failed or neglected to provide maintenance to the wife for a period of 2 years or more. So the period has been fixed. If any Muslim husband has neglected his wife for a period of 2 years or more, then a Muslim wife, she accrues the right, she is entitled to a decree of divorce. That means the inability of the husband to maintain his wife or the failure to maintain her is on account of his poverty, the failure of falling in his health, loss of work, imprisonment, or any other cause, whichever as it may be there. So the Muslim wife, she can ask for the cancellation of her marriage. That means it is his duty to maintain his wife. So on this ground also, a wife, she can ask for she is entitled to get a decree of divorce. So here there are two case laws are there with regard to this aspect, and here with regard to the aspect of whether if the Muslim wife is rich, whether even in that case also, whether the husband has got the duty to maintain his wife, means even if the wife is rich, then also the husband has to maintain his wife. And with regard to a wife who is living separately also, when a wife living separately also without any proper reason, so whether a Muslim husband has to maintain his wife, means even under such stage also, a husband has got the duty, he has got a duty to maintain his wife. So with regard to that one, there is a leading case law is there, that is Yusuf Rautan versus Swaramma. So which has been given by the Kerala High Court. That means no doubt a wife, she accrues the right of maintenance under section 125 of the Criminal Procedure Code of 1973. So in spite of that one, so under this section, that is section 2, subclause 2, that is 2 and subclause 2, where a Muslim wife, she accrues the right that when her husband has failed to maintain her for a period of 2 years or more, so it may be of any reason, so she gets the right to get the divorce. So the third ground where a wife accrues the right to get the divorce is, that is the husband being sentenced to a term of imprisonment for a period of 7 years or more. So this is the third aspect. The wife is entitled to a decree of divorce if the husband has been sentenced to imprisonment for a term of 7 years or more, but a decree can be passed on this ground only if the sentence has become final. So here under this ground also, a wife, she accrues the right to get the divorce under section 2 subclause 3 of the Act. So this is the third ground where a Muslim wife, she accrues the right to get the divorce. So with regard to the fourth aspect, that is the husband's failure without reasonable cause or to perform marital obligation. So this is the fourth aspect has been given. That means the husband he's failed in his marital obligation. Here under this act, it has not been the supplemented. It has not given what is marital obligation. So it has been left to the discretion of the court. So here, when a Muslim husband he has failed to perform his marital obligation, then also a wife she can get the divorce. That means on the failure of the husband to perform marital obligations without any reasonable cause for a period of 3 years or more, the wife is entitled to overturn a decree for the dissolution of her marriage. So the failure it is submitted relates to the basic matrimonial obligation. And next aspect is impotence of the husband. So a wife she can get the judicial divorce on the ground of impotence of her husband. Here now the wife is entitled to a decree of divorce if the husband was impotent at the time of marriage and continues to be so till the filing of the suit. So if the husband is impotent at the time of the marriage and continues to till the filing of the suit, then she can file a suit and she can get the decree in the court of law. So on the application of the husband, but not otherwise, the husband has to prove that he is not impotent. Otherwise, the court may grant the judicial divorce on the ground of impotence of the husband. Here, the leading case on this aspect is Ghulam Muhammad Khan versus Hasina. So here, what has happened? The wife has filed the suit for the dissolution of marriage on the ground of husband's impotency. Here, the husband made an application before the court seeking an order for proving his potency. Here, the court allowed him to prove his potency, and the husband produced the certificate of the medical board that he was potent. But the respondents, that is his wife, she has asked for the re-examination. So here the husband he has preferred an appeal in the Jammu and Kashmir High Court, whereby the Jammu and Kashmir High Court it has cancelled the order for the re-examination by the another medical board. Here this is the leading case law with regard to the impotence of the husband. And next case law with regard to this impotence of the husband, that means whereby a Muslim wife she can pray for the divorce under this ground, is Abdul Azam versus Farimunisa. So here it has been delivered by the Mysore court. Here it has been observed by the court that the wife cannot be subjected to prove the potency of the husband. So that is the wonderful judgment has been given under the Abdul Azam versus Farimunisa, whereby the Muslim woman cannot be compelled to prove the potency of the husband. So this is the another ground where a Muslim woman she can ask for the divorce, that is impotence of the husband. Next aspect is insanity, leprosy, and venereal disease. So on this ground also a Muslim can get the divorce. So the important feature with regard to this insanity, leprosy, and venereal disease, here the Act does not spell out whether the provisions relate to the post-marriage or pre-marriage insanity, or it does not specify the insanity must be continuous or curable or incurable. And here the Act has not considered with regard to the curable aspect or incurable aspect, or whether this insanity was prevailing even before the marriage, or it has come after the marriage. With regard to this aspect is the same with regard to leprosy and venereal disease also. Here it is possible to take the view that insanity under this act has the same meaning as was given to it before the coming into force of the act. Here, similarly, leprosy is a ground for decree of divorce. Leprosy is without qualifications. Even the duration of leprosy is not stated. And here, with regard to the wife, she cannot be what you call denied. She cannot be asked whether it is a curable or virulent or incurable. So, with regard to whether it is insanity or leprosy, the aspects whether the such diseases can be get cured or it cannot be incurable, such aspects has not been taken into consideration. That means the wife can file a suit for divorce on the ground that the husband is suffering from virulent venereal disease, or it may be insanity, leprosy, or anything, and it has not been found place in the under the act. So with regard to the aspect of the curability of these diseases, whether it is under the short form or long form, with regard to all those aspects, the act is silent. So here the Muslim wife, she accrues the right if she alleges that there is the insanity is prevailing on her husband, or is suffering from the leprosy and venereal disease. She gets the right under this act. So here with regard to the venereal disease need not be communicable in form. That the only requirement is threat. The disease should be in a virulent form. Even if the disease has been contracted from the wife will be entitled to a divorce. So yes, the strange thing is that even the disease might have been contracted by the wife, that sort of the venereal disease. So even under such context also, she is entitled for divorce. So the next ground for divorce is a repudiation of marriage by the wife. So here the wife is entitled to file a suit for the dissolution of her marriage on the ground that she was given in marriage by her father or for her grandfather or any other guardian even before she attained the age of 15, that the marriage had not been consummated, and that she had repudiated the marriage before she attained the age of 18. So that can be called, in other words, it can be called as a option of puberty by wife. So here this ground for the dissolution of marriage is not based on any fault of the husband. It is an independent provisions under which a marriage is voidable at the option of the wife. So under section 2 subclause 7, a wife can obtain a decree for dissolution of her marriage if her marriage was contracted by her father or any other guardian during her minority. So here this option of with regard to this aspect of option of puberty, this law can be called as khayarul bulug. So this also can be dealt under the aspect of this option of puberty of by wife. That means the Muslim wife, she can repudiate her marriage on the ground of the option of puberty by her. And next aspect is the cruelty. That is a very important, very interesting aspect with regard to the dissolution of marriage, where most of the marriages will be dissolved on the ground of cruelty. Either it may be Hindu law, or it may be Mohammedan law, or any other law. Here, the wife is entitled to a decree of divorce if her husband treats her with cruelty. That is to say, the habitually assaults her or makes her life miserable by cruelty of conduct, even if such conduct does not amount to physical or ill treatment. That means with regard to the cruelty, mainly the cruelty can be viewed under under 7 heads. So here this concept of this the definition of cruelty can be viewed from so many aspects. So here, with regard to the cruelty, if the husband habitually assaults her wife or making her life miserable by his conduct, then it will amount to a what you call cruelty. That means such conduct it need not be in the physical ill treatment. Just if he does not if he does not talk with his wife, he is not normal with his wife. So at that time also, that act of husband can be called as cruel. So here the habitual assaults her makes his wife's life miserable by cruel conduct, even if such conduct does not amount to physical ill treatment. Here, the leading case law with regard to this aspect is Siddiqui versus Amina. So here, it was established that husband had administered his wife some drug causing miscarriage. That means husband has given some drug for the miscarriage of his baby. So it will be covered. It will be judged under the concept of cruelty. And he has also physically tortured her. It was a clear case of cruelty. So here number of things has been discussed under this concept of cruelty. The second aspect is if the husband associated with the woman of evil repute or bad conduct, then also the Muslim wife, she can ask for a divorce under the ground of cruelty. And next aspect is if the husband attempts to force her to lead immoral life, so then also a Muslim wife, she can file a petition under the cruelty for the dissolvement of her marriage. The other aspect is suppose the husband disposes the property of his wife, whether it will be a cruelty means even if the Muslim husband disposes her property or sells away the ornaments of his wife, it will amount to a cruelty. So this aspect has been rightly appreciated under the case law of Jubaida Begum versus Sardar Shah. Here, the Lahore High Court has come to the conclusion that if the Muslim husband has sells or assigns wife's property without her it is against to his wife's will or without the consent of his wife, it will amount to cruelty. On that ground also she can get the divorce. The next aspect is the husband obstructs his wife in observance of her religious profession or practice. That is, it is submitted that the clause will apply even when the wife is non-Muslim. So here, this is very very interesting thing. That means here this aspect will applicable even his wife is a non-Muslim. That means if a husband obstructs her to do the religious profession, the practices of her religious profession, then also she can ask for the divorce. So here, with regard to this one, this aspect also will be treated under the concept of cruelty. And next aspect is the Quran enjoins that a man should take more than one wife. That means only when he can treat them all equitably. That means if a Muslim husband does not maintain his wives, that means if the Muslim husband does not maintain his wives equally, that means, as you know, a Muslim husband, he can marry more than one. That means up to 4 he can marry. But what the Islamic law says that you should not go for more than one. If you are capable to maintain all the wives, that means if you are capable to have the capacity to maintain all the wives, that is even you are entitled to get 4 wives, but it is your most the obligation duty to maintain all these wives equitably. That means it is a human impossible to maintain all these wives. So it is you can go for one only. That means, but the option has been given to you, but you have to maintain all these wives equitably. So here what we have to see, here if a person does not look into the all these wives equitably, then also a Muslim wife can get the what you call the ground to file the petition under the ground of cruelty. So here what happened in Umtal Hafiz versus Taliba Hussein, where a husband went abroad leaving behind his two wives in India. He provided maintenance for one wife from there but ignored the other. The court held that the other wife was entitled to divorce under this clause of the under this clause. That means, so with regard to the under this clause means section 2 subclause 8, a woman, she can file the petition under the ground of cruelty when he has got the obligation to maintain all his wife equitably. When he failed in his duty, it will be amounted to cruelty. So these are all the instances where we can see the cruelty has been dealt under these concepts, where a Muslim can Muslim wife, she is entitled to get a decree of divorce. So under these grounds, a Muslim wife, she can accrue the rights, she can file the petitions under these grounds. So that is first one is if Muslim husband is his whereabouts are not known for a period of 4 years, and second one is the failure of the husband to provide maintenance for a period of 2 years, and third one is the husband has been sentenced to a term of imprisonment for a period of 7 years, and next aspect is that the husband's failure in performing his marital obligations for a period of 3 years, where the wife can get the right to get the divorce. And next aspect is impotency, leprosy, venereal disease of the husband, and insanity of the husband, and the repudiation by the marriage by the wife, that is option of puberty, and last one is cruelty of the husband. So on these grounds, a Muslim wife, she can entitled to get a decree of divorce. So here, what about the concept of the Lian and Faskh? So with regard to the Lian, what is Lian? I have said in the beginning of this video. So here, with regard to Lian and Faskh, so the aspect of this one has been dealt under the section subclause 9 of this Act. So here, under section 2 subclause 9 of the Act, it has been provided that any other ground which is recognized as valid for the dissolution of under Muslim law. That means it is a significant thing that under section 2 of the dissolution of Muslim Marriage Act of Muslim Marriage Act is not limited to only to Lian. So here the wife may seek the divorce for dissolution of her marriage on any other ground which is recognized as valid under the Muslim law. So what I want to put to that, under the grounds, whichever the grounds, that is, it is a here the Muslim wife, she gets the rights. She may say she may prove before the court that under any other grounds she can claim for the decree of divorce. So under section 2 subclause 9, this Lian or Faskh, so that means under this Lian she can get the divorce. What is Lian means? It is a false accusation of adultery on a Muslim wife. That means Lian means it is right available to a Muslim wife on the false accusation of adultery, commission of the adultery. So that is Lian. This Faskh means the filing of the petition, getting the divorce. So under section 2(9) of this Act, we can this Lian also has been covered. So in the Muslim law of modern India, the wife is entitled to sue for a dissolution of marriage on the ground that the husband has falsely charged her with adultery. So it should be noted that the charge of adultery by itself does not lead to the dissolution of marriage, but she has to file the petition. So that can be called as Faskh. So the decree of the court she has to obtain. So then the marriage will be dissolved. So the court will pass a decree if the charge of adultery by itself does not lead to the dissolution of marriage, but the decree of the court has to be overturned. So more than this one more aspect we have to see with regard to the dissolution of marriage, that is apostasy. So what is apostasy? Means the renouncing or giving up one's own religion. So before 1939, either the party to marriage, if they renounce the Islam, the marriage gets dissolved immediately, whether the renunciation of Islam may be by husband or wife. But after the commencement of the dissolution of Muslim Marriage Act of 1939, this aspect has been modified under the section 4 of the Act. So here with regard to apostasy, we have to see it may be apostasy by husband or by the apostasy by wife. So if a Muslim husband renounces Islam, the marriage dissolves immediately. Under section 4 of the dissolution of Muslim Marriage Act of 1939, it does not apply to the apostasy by husband. That is, the result is that apostasy by the husband is still governed by the old law. So that is with regard to the apostasy by husband. But what about the apostasy by wife? Means if a Muslim wife renounces Islam, the marriage is not dissolved. That means, in other words, what we can see, the apostasy by Muslim wife does not operate itself as the immediate dissolution of the marriage. That is, she has to file a petition before the court under the section 2 of the Act, what we have discussed so far. That is, she continues to be wife of a married, she continues to be a wife married under the Muslim law. But this will not applicable to the converted Muslims. So with regard to this aspect, we can see under the this aspect with regard to the converted Muslims, we can see this aspect under the next video. So the other aspect has to be seen under this the dissolution of marriage is the breakdown of marriage as a ground of divorce. That means here this breakdown of marriage is a it may be because of any other thing also, because as you know that the differences between the husband and wife may be it is common. It may be with regard to the trivial differences. It may be with regard to the any other aspects which has not been covered under this section 2. So at that time the court has to see whether it is proper to give the divorce to the couple, because here what we have to see that under if the divorce has been given with regard to the, if there is no mutual adjustment is not there, if there is no matrimonial adjustment is not there, that means, so with regard to the such aspects, so then the breakdown of the marriage it will be very much it will be very much common. So rather than that, the court has to see what you call the genuinity of the reason with regard to the breaking down of the marriage. So this aspect has been said by the Justice Krishna here in number of judgments. Here in one of the judgment he has said that daily trivial differences get dissolved in the course of time and may be treated as the teething troubles of every matrimonial adjustment. Likewise, he has observed very beautifully with regard to the breakdown of marriage as a ground of divorce. So with regard to this one, today we have covered the dissolution of marriage under the section 2 of the dissolution of Marriage Act of 1939.